is brought to you by Falsani, Balmer, Peterson, Quinn, and Beyer. For nearly 40 years, answering the Northland's toughest legal questions, helping you understand where you stand. Falsani, Balmer, Peterson, Quinn, and Beyer.
Good evening and welcome to Lawyers on the Line. I'm Stephanie Balmer, a lawyer with the Falsani, Balmer, Peterson, Quinn, and Beyer law firm, and this evening's moderator. Tonight we're talking about wills and estates. The idea of planning for your later years and beyond may be overwhelming, but these days even your primary care physician wants to know if you have a will. As they say, time flies, and preparing for the end is always a good idea. Mark Signorelli of the law office of Mark Signorelli and Ray Peterson of the Maki Overom law firm are here with us tonight. They're ready to take your questions, so give us a call right now at 218-788-2844, or if that's long distance for you, call our toll-free line at 1-877-307-8762. Well, let's start off with the softball here. What is estate planning?
Well, the words Stephanie, define themselves. It's planning for your estate, the management and transmission of your assets in the event you become incapacitated or unable to manage your assets, and then after your death.
All right. What should someone do to start the estate planning process, Ray?
I would recommend to gather your affairs. And obviously I would encourage you, and I believe Mark would too, work with an attorney. Someone who's experienced in this area. You just want to gather information, your assets, information about loved ones, and start thinking about, as Mark mentioned, if I did get sick or if I did pass away, who's going to step in? Who's going to be the person that you're going to go to, be able to make decisions and act on your behalf?
Here's another hopefully straightforward question. What is a trust, Mark?
Well, a trust is not a will, but it can behave like a will. It can say most of the same things that a will says, but a trust is a contract between you, and you're often called a settlor, and a trustee, which in Minnesota you can be your own trustee as long as you're competent. But then you would name a successor trustee who follows the script of the trust in the event of your incapacity or death.
Ray, let's start with you. What 2 tips do you have for creating a will for a family with a child who has special needs? Let's start with 1 tip. You give us one, and then we'll have Mark give us another.
Well, I would, maybe some options there, I guess. There is some relief, I would say, under congressional and state statutes to allow people to create what's called a special needs trust or a supplemental needs trust. They're a vehicle in which families, loved ones can plan for somebody who does have disability, is disabled, has special needs. The purpose of these vehicles is to allow the person to maintain public benefit, but also retain the benefit of those assets, because oftentimes in our public assistance programs, they tie it into what your assets are. So if planned properly and done properly, those assets can be set aside and not included when determining one's eligibility. And the beauty of that is then oftentimes families don't feel like they have to leave somebody out or disinherit somebody. So Mark can probably add to that, I'm sure.
There's also what Ray was talking about were trusts that you create or the court creates for the disabled person. If people are really only able to set aside modest amounts, there's also a section in the law called a pooled trust that's sponsored by qualified organizations. And it's really like a big mutual fund into which you put the child's assets, and he or she benefits from them like a regular supplemental needs trust. In the end, those assets repay the state to the extent they have paid out for the disabled child.
All right. Here's another basic question. Does everybody need a will, or can you get away without doing one? Mark, you want to start?
Well, yes. A will is really intended to pass assets in your own name through the probate process, which we may come to later. But there's many ways that assets can pass. A life insurance policy, for example, if you designate beneficiaries, those assets aren't probate assets and won't be governed by a will. The same is true with a joint bank account that becomes the account and the owner or the property of the survivor. Again, will not pass through the probate process, and the will means nothing.
I think, and to add to that, when people think about wills and trusts, as Mark mentioned, there's, you can do beneficiary designations, and oftentimes, not always the case, those vehicles for distributing assets upon one's death can be done, I think, without a filter. They just kind of go to the people. Sometimes that's okay, sometimes that's not okay, meaning sometimes we need a filter there to say, well, how should these assets go to somebody? And a lot of times that's what having a well-crafted will or a trust will act as that filter. Do you have young children? And if something were to happen to you and your assets pass to your children, you don't want them to go directly, or you want to put parameters and who's acting and stuff like that. So the wills and trusts, I try to get clients to focus on, this is your filter. This is how the assets are going to go. This is your plan. But again, there's many tools, as Mark says, to distribute assets.
And for the younger couple with children, probably the most important reason to actually have a will is to nominate who will be the guardians and take care of those children if both of you should die. That's really a concern of many people.
On a related note, should people make their own will, or is that something they should seek counsel for?
Well, you can make your own will if you do it right. One of the prettiest wills I ever read was the will of Chester Congdon, who was himself a lawyer, not practicing at the time, but he wrote a wonderful will.
Really?
If you can get your hands on it from the courthouse. The other will, which was also written by a lawyer, Warren Burger, Chief Justice of the Supreme Court, he made a mistake in his own will, and it cost his family close to $500,000.
I would add to that, a simple caveat I always say, I don't do my own plumbing, and there's a reason why. It seems not to take away business from all the online business out there, but sometimes this access it almost makes it too easy, and people may not understand what they're getting into, what they're downloading, what they're actually executing. A lot of the attorney's job, I believe, in the estate planning process is to be a bit of the devil's advocate and to poke holes in people's theories and get them to think about the what ifs and if this happens, what happens. The contingencies, really important to have something that's well crafted.
What about going back to who can create a will or who can sign a will? Could a person with dementia execute their own will?
Yes, maybe. Dementia and Alzheimer's, those are medical definitions. Lawyers deal in legal definitions, and the definition is capacity. Did the person with dementia have at the time they executed the will the requisites for capacity, testamentary intent, those kinds of things?
It's referred to sometimes as the lucid interval, where at that point did the person understand the natural objects of their bounty, so and that's kind of the test. And again, it's a legal test, I run into that quite a bit, and I know Mark does too, where people say, well, mom or dad has Alzheimer's, they can't do anything. And obviously there's a spectrum to all of that.
And there's good days and bad days.
Exactly. So it's not for, it gets very complicated quickly. So.
And you can also write the will in plain English. I'm sorry to admit, often people think we write wills not in plain English, but for a person who's got a bit of a cognitive problem, you can write the will in plain English, and if they have a vision problem, of course, you can make it in big type. And even if they're blind, they can sign a will if they've got the requisite capacity.
Here's a pretty specific question. My mom passed away and had a power of attorney naming me. I went to my local bank and it won't allow me to access my mom's accounts. Her bills are piling up. Isn't the bank wrong? Ray, do you want to start?
The short answer is no, the bank is not wrong. Kind of a common misperception is about powers of attorney, and they revoke upon death. And it's pretty I get that one a lot of times where clients will come in and say, Mom or Dad passed away and I'm the power of attorney, and I have to politely correct them and say you're no longer the power of attorney, because that ceases upon death. So, and then you might get into probate, would make the decisions about who's going to be in control, or if the estate is below certain levels, you can collect by affidavit.
Here's a question, Mark. A caller from Duluth wants to know, their dad has a trust. The trustee is refusing to disperse the inheritance to the family because of estate taxes. Why?
Well, the trustee is primarily responsible for the after-death tax matters, the final income tax return, those kinds of things. One of them is if an estate tax applies, the trustee can end up being personally responsible if he passes the assets out to the beneficiaries, and then the IRS comes calling, or the state of Minnesota.
So it may be that the trustee will disperse something later on after things have settled down a little bit?
Yes, it's possible to make some distributions and reserve funds sufficient to pay the taxing authorities.
Okay.
Yeah, I would add that, I mean, seeing a lot of clients, people sometimes are eager to get the money and stuff, but if you give it all away, it's a little harder to ask for it back. So you do want to make sure that the taxes are all taken care of, the bills are all paid, so nobody comes knocking, so to speak.
Here's a question. Does everyone have to go through probate?
Well, no, there are, as we talked before, some tools to avoid probate, the joint tenancy with real estate, those kinds of things, and a simple trust, which can be a will substitute. And so, no, you can not go through probate if you work at it.
The probate, I always tell people that's optional, you know, and you have to do advanced planning, do estate planning, if that's your goal to avoid it. And as attorneys, it's not our goal to determine what the client's goals are, so we need to listen to them and understand what they want. Oftentimes, clients do want to avoid probate, and then we provide the different tools that can be there to do it for them.
This sounds like it may be related to the special needs issue. What is the best way to protect assets against medical care costs, if there is a way?
I have a hunch that's hinting at medical assistance or Medicaid. It's
okay.
When you get into the senior years, people start worrying, can I afford to pay for my care if I become disabled? Would I have to go to a nursing home? Will all my funds be consumed? Will my spouse still have funds to live on? Those kinds of things. That's a whole subject that I guess is referred to as elder law and medical assistance issues. It's quite complicated, and it's often not pleasant for the client.
And there's not one answer, but I would tell people that there are options. And it's important to explore those options and at least pick up the phone and ask somebody, is there anything I can be doing here? Because there can be some planning done to hopefully preserve assets, whether it's for a spouse or to leave a legacy to the kids. So very complicated area though.
Okay, this is a question from a caller. A wife and a husband have a quitclaim deed on a house to save for kids, but have renters reserve life estate. Trying to interpret this question. Can that be changed? Does that make sense?
It sounds like they may have, the renters, either somebody that's living there now, it sounds like they granted a life estate. I would they can't take away the life estate without the consent of the people who they gave that to, so that aspect couldn't be changed. Whoever what is referred to as a remainderman, or the people that would get it upon death, that could possibly be changed. You'd have to look at the deed and see what it says, but that definitely could possibly be, I should say, be changed if as far as who gets it in the future or upon death. So.
Okay. Here's another question from a caller. If you have a child on your bank account and you die, can your child still access your account? So maybe if there's two names on the account?
Typically, yes, and we see that quite a bit where mom or dad have put a kid on there usually for access. They may not have understood that they put them on as an owner, and I caution clients with that because in a simple sense, I always say if you put the kids on the title of your assets, their problems become your problems. And but that sounds like it's a joint account, which means it would avoid probate. Joint ownership is kind of the last person standing rule. Whoever lives the longest gets it, so it would automatically transfer to that survivor. The tricky part gets in that if there were siblings, and then the question is that if it was only one sibling on there, is that one sibling going to share it with the rest if that was the intent? So
that does cause a lot of difficulties. In the one case of putting a child's name on a safety deposit box, be careful that they're not just a deputy and they can have a power of attorney to get in while you are alive. Mm-hmm. They should be a co-owner with you with the same rights of entry, so that after you die, they've got the key and they can get into the box without a court order.
Oh, okay.
Run into a lot of problems with the safe deposit boxes. People stick important documents in there and we can't get to them. It's safe but not too safe in my mind.
All right. Here's a question from a caller. Her mom is living in her grandma's home. If mom died, who would get the house without a will? So it sounds like there's a matriarch who owns a home. Oh, I'm sorry. I think maybe the matriarch died, and so the woman is living in the house, but her name is not on, she doesn't own the house.
And so the deceased died without a will. In assuming the deceased's name is on the title, it would be a probate matter, presumably, because it's real estate, so that would realistically have to go through probate. And then it's going to be, if somebody dies without a will, it's called dying intestate. And if people don't think they have a will, they do have one. The state wrote it for you. Mm-hmm. And so there's some presumptions, and it gets complicated if it's a second family situation. But if it's, typically it's the family tree, so to speak, as far as who it's going to fall to.
And the daughter living in the home, if she has siblings, they're in for a piece of the home at the time of probate.
So the woman living there doesn't, she doesn't get to decide where it goes?
She doesn't have squatter's rights.
Okay. Mark, how often should a person update their estate plan?
Well, this is where self-help is important. I recommend that every year at home by themselves, that a husband, wife, or a single parent sit down with the file drawer at home where they keep their important papers, and they keep updating them as things go along. Things change. You change bank accounts, you change jobs, you change insurance. Update that file every year on your own. Then if there's a major event that occurs, somebody passes away, a child becomes desperately ill, it may be time to talk to a lawyer about making some changes in what used to be a fairly plain vanilla will arrangement.
I have a question along those lines. In terms of social media and email accounts and things like that, if someone were to pass, what happens with all those accounts? Can anybody access them? Can you plan for that?
You can try to plan for that. The laws around the nation are murky. They are trying to get a uniform law about the ownership and access of digital assets. And for a while now, we've been throwing in a digital assets clause just in case, because some of the providers say, well, it's up to your executor, which means you may have to have a probate. Who physically owns the account? And we usually put a small clause in our documents that designate who is the owner of your digital assets if you die.
Okay. Here's a question from a caller. Can you put your home and cabin in your kids' names? And if you do, and the kids file bankruptcy or get divorced, how can you ensure that the property stay in the family, if at all?
I guess going back to my caveat that if you put the kids on the title, whether you're with them or not with them, their problems could affect that thing. So could a divorce? It could. Don't quite see that as much. The financial issues would be what I would be more concerned about if a kid files for a bankruptcy or the like. Definitely would have issues. strongly caution against people putting the kids on the title. Not only their problems, but there's potentially some very adverse tax consequences down the roads to the kids, in the sense that the parents are giving up the right to what they do, the step up in cost basis. And it can, a lot of times people say, well, I was trying to avoid probate. Okay, and now your kid's got to pay taxes probably tenfold of that. So that a lot of times that doesn't make sense. So.
It sounds like we're getting questions in response to things we've already talked about, which I think is really interesting. A woman has called in. She's got 3 kids, I assume grown kids. Should she have all 3 kids on her bank account to access when she dies? So maybe that goes back to...
If she's really trying to avoid probate, there are easier ways of avoiding probate than
Okay.
that, because I always say multiple children on the bank account is the fastest race since the Indiana 500. The first person to the account owns it.
Mm-hmm.
Okay.
And the bank says, we didn't do anything wrong, and they're right.
All right.
The other issue that a lot of times the parents are trying to give the kids access, and I think there's a better way there, and that's by doing a fairly simple document, a power of attorney, that gives somebody the ability to access the account, but doesn't necessarily give them ownership, and their problems because they don't have ownership. If that person you appoint has issues, it's not going to affect the account. So.
Sure. And with the power of attorney on the one hand and a pay on death designation on the account, you can pretty much control where that account goes if your pay on death designation is specific and is accepted by the bank.
Do most banks include that as part of their account opening process, as far as...
Not to my knowledge.
So that
Not
would,
really.
That would be a special request or something that
Sure.
Yeah.
a lawyer would help you make of your
Mhm.
bank. Okay.
They're not going to presume that, I don't think.
Okay. Here's a question from a caller. Can anyone get into a safety deposit box who isn't listed as part owner? So if there's one person and they're the owner of the security deposit box, the safe deposit box, and they pass, what happens to the contents of...
There's a joint owner on there?
No, it
Just
sounds
one
like
owner?
nobody's listed as part owner. So can anybody get into it once the owner
Yes, with
passes?
a court order, a drill, and a sheriff standing next to you.
Is that pretty typical?
We've done that before.
Okay.
Yeah, you can file an affidavit. Usually the banks will allow you to inventory what's in there, to go
okay.
in there and decide, is there anything we have to probate inside of here, but it's safe deposit boxes are, they need to be planned for carefully.
Huh.
And
Okay.
like Mark had talked about earlier, having somebody else on there or making sure people have access. So.
If there's a power of attorney prior to death, is there any way to continue that role after death and not be extinguished upon death? So, I mean, what would be the vehicle to do that?
Well, a living trust
Okay.
that's funded or to which the assets pass could take over from where the power of attorney quit, and it could be the same person as successor trustee who held the power of attorney prior to death.
Okay.
And the other one on that would be if there isn't a trust, like Mark said, and that's an excellent tool because there's consistency throughout. But also, if there's a power of attorney but no trust, and a person dies, the will is probably, if they have a will, that's going to direct who the person is to act on behalf of the estate. Very similar roles, where in Minnesota we refer to it as a personal representative. So they handle the estate in probate after death.
So it can be the same person. There's no rule against that.
Absolutely.
No.
I would just say they're wearing different hats. They have different titles on their shirt at that point.
Okay.
On the subject quickly of a power of attorney, we haven't talked about healthcare directives, but if the strata of children is, let's say, 18 to 30, when a child reaches age 18, he's legally capable, and he can sign a power of attorney and a healthcare directive, and especially if they're going away to college. That's something the parents can really encourage their children to do.
Mm-hmm.
Is a healthcare directive something that a person should do on their own, or is that also something that you should seek legal counsel for?
Well, they can do it on their own. The hospitals and some, I think, clinics would provide a form to use. There's various different kinds of forms. They can be very simple, or they can be quite lengthy. And when you're dealing with the seniors, to hand them a 20-page healthcare directive just doesn't work with them. It's got to be simple, direct, and what they want done.
Typically in the healthcare directive, the primary function is you're appointing somebody to make medical decisions. And I have a tendency to, I want to keep it broad. I don't like to narrow it down for these or that decisions. And a lot of times people want to add stuff to it, and I'm a little cautious about putting more stuff into writing because I think it can become a matter of interpretation later. So I think the important thing, particularly with the healthcare directive, you know, generally you appoint the person, the agent, to act. So that person has the ability to make any medical decisions, communicate with your healthcare providers, and usually there's a terminal conditions instruction in there, the proverbial pull the plug type of stuff, where end of life measures and who can make that decision. It is very important to have. Just like the power of attorney, and a lot of times with the estate we focus on the financial aspects of it, but on the healthcare it becomes very, very emotional. And you know, we start seeing fights in families if you don't have the person you want to be making these decisions.
Do you both have a healthcare directive?
Yes.
Absolutely.
All right. That's all the time we have tonight. Remember, you can watch our show again online at www.wdse.org or at www.duluthtriallawyers.com. Please join us again next week when we'll be talking about the death of the civil jury trial. I'd like to thank our panelists for their expertise this evening, and thank you for watching. I'm Stephanie Balmer. Good night. Like, what? You know this? And Ed afterwards said, oh man, I could totally tell she didn't know the answer to that question.
If you want, you can do a run through for your promo.
Oh, like a practice?
Yeah.
Are you suggesting that I do so?
Yeah.
Okay. Oh, I took off my thing. Should I
Yeah,
put it
you
back
bring
on?
your mic back on.
Oh. I got all excited for being done. Civil trial by jury is guaranteed by the United States and Minnesota constitutions. Yet trial by jury in civil cases is becoming increasingly rare and difficult. Why and how is this happening? Find out next time on Lawyers on the Line, Thursday nights at 7:30 on PBS North. Okay, that was a practice, right?
Yep.
All right, good. All right, I'm ready.
Yeah, your practice.
Civil trial by jury is guaranteed by the United States and Minnesota constitutions. Yet trial by jury in civil cases is becoming increasingly rare and difficult. Why and how is this happening? Find out next time on Lawyers on the Line. Lawyers on the Line. Thursday nights at 7:30 on PBS North. Sorry.
Good practice again.
All right. I have to get it. Civil trial by jury is guaranteed by the United States and Minnesota constitutions. Yet trial by jury in civil cases is becoming increasingly rare and difficult. Why and how is this happening? Find out next time on Lawyers on the Line, Thursday nights at 7:30 on PBS North.
Just one more.
You're not waiting for me, are you?
Great.
Civil trial by jury is guaranteed by the United States and Minnesota constitutions. Yet trial by jury in civil cases is becoming increasingly rare and difficult. Why and how is this happening? Find out next time on Lawyers on the Line, Thursday nights at 7:30 on PBS North.